Welcome back. We're going to reconvene our symposium. We're here with our distinguished lecturer now. This is Professor Eileen Gauna. She is the Dickinson Professor of Law at the University of New Mexico School of Law. So she's traveled quite a long way to be here with us today. She's a graduate of the New Mexico School of Law, and she teaches actually a course on environmental justice there at New Mexico. And her course book, which she's developed, has been a very influential course book in law schools throughout the country. She's testified before the Congressional Committee on Climate Change and Energy Security. She has been involved in a White House forum on environmental justice, so she's among the most well-known in environmental justice in the country and in the world. We're really fortunate to have with us today Ms. Eileen Gauna. What we're going to do is she's going to speak for about 30 minutes, and then we'll have about 15 minutes of questions, and then we'll go ahead and introduce our keynote speaker. So it's my privilege again to introduce Ms. Eileen Gauna.
Can everybody hear me? Can you hear me now? Okay. Well, first, thanks for inviting me to Mizzou? Okay. The inaugural symposium here of the Journal of Environmental Law and Sustainability. So you're dedicating the inaugural symposium to exploring the link between environmental justice and sustainability is dead on. It's really fitting because it gets right to the heart of the matter. A noted friend of mine, an environmental justice activist, once quipped, "Hey, we're all in a sinking ship. People of color are just closer to the hole in the hull." And this intuitive metaphor, I think, captures the idea that we really can't get to a sustainable level of development until we deal with a very hard set of questions and issues that have been raised by those in the environmental justice movement. When I started thinking about the connection between environmental justice and sustainability generally, I really began to reflect upon all the various twists and turns in the way that participants in this area have talked about environmental justice. In some ways, there's been a disjunction in the discourse. In the domestic context, for example, activists have employed the language of civil rights, basic fairness, the precautionary principle, and even more recently, the language of human rights. In parallel conversations in the international context, you also see the use of a human rights framework, and at times you see an analysis of environmental justice issues as the continuation of a colonial legacy, as was talked about this morning, and also stemming from the dominance of a neoliberal economics model. On both of these fronts, these views have been met by a discourse more influenced by economic, scientific, legal, and engineering frameworks. So what I'd like to do today is focus more on the domestic context, where I think these issues have more concretely crystallized around viewing environmental justice issues from a civil rights framework and also from a competing environmental law framework. I want to discuss the limitations of each of these frameworks and the disconnect between the two models. I'd then like to offer a few exploratory thoughts on how principles of sustainability fit into the picture. Sustainability might be used to maintain the inequity of the status quo, or in light of climate change, sustainability might also be used to unintentionally create a new kind of inequity. On the more positive side, a framework oriented towards sustainability, coupled with a sensitivity towards environmental justice concerns, might help bridge this existing chasm in the discourse and perhaps provide a space for the development of an area where there really can be more common ground. Well, common ground, it sounds kind of nice. It also sounds kind of anemic. Too weak for the oppressive and persistent problems that caused people of color and the poor to live in unacceptable conditions for a long time. And this may well be the case. But sometimes when perception shifts just a bit some interesting things start to happen, and therein lies the potential. But before I get to that, let me briefly address environmental justice and civil rights. We know that environmental justice is about 3 decades old. The charge as originally expressed was one of environmental racism, a provocative indictment, particularly because it was not aimed at segregationists or white supremacists, but at well-meaning regulators and even liberal-leaning environmentalists. Of course, by the early 1980s, our understanding of racial dynamics was more nuanced. We knew that racism didn't go away when overt bigotry, so captured by the iconic images from the civil rights era, became safely tucked away in archives and history books. But still, it was surprising. In the 1980s, we understood the dynamics of more subtle forms of discrimination, such as unconscious bias and institutionalized racism, that manifested, for example, in workplace conditions. But few had thought of the possibility that embedded within environmental regulation, within the technicalities of permitting, standard setting, cleanup, and enforcement, were practices that could by any stretch be called racist. But there it was, and activists were insistent. What else could explain the oppressive pollutant loads in people of color communities? Why did these communities get the bad smells, the unrelenting truck traffic, the noise, the dust, the light? Why did these people end up with high rates of respiratory illnesses, unexplained rashes, cancer clusters? To them, the answer was obvious. It was racism, sometimes intentional, sometimes not, but it was racism. The disparity that they could see by just looking around and what they were experiencing in their communities soon found validation in empirical study. Understandably, there was pushback. Nobody wants to be called a racist, especially if you think it's simply not true. The initial response was that the studies weren't well done and couldn't really be said to validate that charge. Then came the observation that even if there were existing patterns of disparity, that again said nothing about its cause. These patterns were not the result of discrimination, but instead were the result of market forces. Residential land near polluting facilities becomes cheap. People then move to those areas. No one forced them to do so. And since it was a voluntary choice, then all things considered, they must believe themselves to be better off buying and renting in these areas, accepting the trade-off of lower housing costs, but more pollution. Unfortunate, perhaps. Racist, hardly. A softer version of the market dynamics theory would concede that while racial disparities should not be so glibly assumed to be acceptable, attempting to redistribute by site shifting some of these facilities, under a progressive siting scheme, for example, would be futile because market dynamics would simply cause the same patterns to emerge over time. Now, to be fair, the debate, as I've just characterized it, is an oversimplification. At both ends of the spectrum, as well as those that fall somewhere in the middle, all soon came to realize that environmental disparities stem from a complicated, interrelated mix of factors. To be sure, there are likely those siting decisions born of a conscious intention to take advantage of people in weaker conditions, including those in people of color communities, although direct proof of that would be exceedingly hard to come by. But in addition, some of the existing disparity is a legacy of historical discrimination in land use, zoning, and residential sales. Demographic shifts and conditions that weaken informal social structures are also part of this mix. For example, communities that are undergoing what some have at times referred to as ethnic churning, that is, an area whose demographics are changing from being predominantly one ethnic minority to another ethnic minority, are communities that are less able to organize and oppose unwanted land uses in their neighborhoods. And the way that environmental laws themselves are implemented may be part of this cause as well, as I'll talk about shortly. The latter point is important because as environmental laws were perceived to be part of the problem rather than the solution, it was only natural to look to equal protection theories and civil rights laws to challenge these practices. Equal protection challenges were soon abandoned because of the high evidentiary burden involved in proving discriminatory intent. But civil rights challenges continued because a disparate impact alone could support a claim. There was no need to show that anybody actually intended to discriminate. What then resulted from this legal strategy was a clash between looking at environmental justice issues through a civil rights lens and looking at these issues through the requirements of environmental laws. Now, this clash is significant, particularly so when thinking about remedies. Now, let's take an environmental justice scenario that's been hotly debated over the years: the deceptively simple act of permitting a facility to emit pollution under federal environmental law. State environmental agencies often have delegated authority to issue these permits, either to new facilities, but more often as renewals to existing facilities. However, surrounding these facilities are residents in largely people of color communities who say they already have far too much pollution than is healthy. And by the way, far more pollution than one will find in wealthier white communities. Issuing the permit under those circumstances thus constitutes an act of racial discrimination. Since Title VI of the Civil Rights Act precludes recipients of federal funds from using criteria or methods that result in a discriminatory impact, the state permitting agency who receives federal funds must refuse to issue the permit. Now, phrasing the issue in this way, I think, puts in stark relief the difficult choice presented. The permit would undoubtedly go forward under environmental laws. The correct pollution control equipment is in place or will be in place, and the permit applicant has met all of the specific requirements applicable to its operations. To go even further, state permitting authorities say that their hands are tied. They have no legal authority to deny the permit, even if they wanted to. So here we have it. Are we really going to demand that the permit be denied, causing the shutdown of a huge facility like an oil refinery? What about the attendant job loss and economic dislocation? What about the implications for national security? Worse still, what if shutting down the plant will help conditions somewhat, but it will not completely remedy the discriminatory impact because of other polluting activity in this area? Yet isn't that the whole point of civil rights laws? To prevent discrimination even when it arises by the application of laws that are neutral on their face? Granted, there is no overt bigotry here, no injustice in that sense, but tons of pollution stemming from business practices motivated by profit are just as harmful as tons of pollution generated from practices motivated by discriminatory intent. And to bring environmental policy into the mix a bit, isn't it time, they argue, to prevent the piecemeal rebuilding and expansion of these facilities that have been largely grandfathered, that is, exempted from stringent pollution control requirements under current environmental laws, with the idea that they were at the end of their useful lives? So from that perspective, and for all these reasons, a civil rights effects-based remedy should work. But it hasn't. A civil rights remedy has not worked in the environmental law context for several reasons. First is that the Supreme Court cut off a private right of action for a claim premised upon disparate impact. This left only administrative investigations and the potential cutoff of federal funding to state agencies whose regulatory practices cause or exacerbate disparate impacts. While there's a lot of talk about Title VI cases, meaningful remedial action has been, according to some, virtually non-existent. Thus far, the EPA has formally found a disparate impact and imposed a remedy in one recent case in California, and the remedy in that case was essentially additional monitoring and community outreach. This lone, and to some an ignominious remedy, stands out from the over 200 civil rights complaints filed with the Environmental Protection Agency thus far that have largely been dismissed or have not been resolved. Other federal agencies have not done much better. So why has this happened? Here's where environmental law enters into the picture. As I mentioned earlier, state regulators, in response to these civil rights claims, have insisted that they have no authority to impose permit requirements other than those explicitly called for under environmental statutes and regulations. That authority does not extend to remedying causally complicated social ills. In this context, they argue, civil rights are limited by environmental law, and environmental law is itself limited. But what that authority is, by the way, is highly contested. Organizations such as the Environmental Law Institute and the National Association of Public Administrators have analyzed federal environmental statutes and have concluded that there is significant authority to address environmental justice concerns, while the EPA and the states remain very cautious about exercising that authority. The importance of resolving the issue of legal authority under the environmental statutes cannot be overstated. This is because in the environmental justice context, there's an obvious limitation to using civil rights legal theories. Poor white communities are not a protected class. But if there is significant legal authority under the environmental statutes to address racial disparities in order to remedy civil rights claims, then there's sufficient legal authority to address disparities in poor white communities as well. Notwithstanding the legal authority issue, environmental justice activists also insist that EPA is simply conflating civil rights with environmental laws, and in essence, civil rights are not limited by environmental laws, they trump environmental laws. And so on the civil rights front, this impasse continues. So what about the environmental law front? I think it would help to stand back and look a bit more broadly at why there's such a disjunction between the civil rights approach and the environmental law approach. As pointed out by some, civil rights aim to provide justice to the individual. They do so largely by protecting minorities from majoritarian preferences, even where it may be economically inefficient to do so. In the civil rights area, we see case-by-case adjudication of individual rights, and sometimes the imposition of remedies that supersede the application of otherwise facially neutral criteria. In contrast, environmental laws aim to provide an optimal level of pollution control, one that is protective but does not provide a risk-free environment. Environmental law relies less upon court-ordered remedies. It is regulatory. However, through the rulemaking process, standards are often relaxed to address concerns about cost and feasibility to regulated entities. When environmental standards are completely health-based, i.e. cost-blind, these standards often end up being insufficiently protective for environmental justice communities as well. A good example of this is in the National Ambient Air Quality Standards under the Clean Air Act. Without going into mind-numbing detail, these standards are implemented by averaging pollution concentrations over a period of time in large airsheds. This averaging can hide concentrated localized pollution that may be affecting a community whose residents live in poverty and who have health vulnerabilities, such as abnormally high rates of asthma. This is the toxic hotspot concern that affects so many environmental justice communities. In addition, regulatory activity is supported by risk assessment. Now, to be sure, risk assessments often employ conservative assumptions, and as such, they are often criticized by business interests as being overly protective and exceedingly costly. But while a chemical risk assessment may seem overprotective in isolation, that overprotectiveness may well turn into underprotectiveness once one confronts the pervasive scientific uncertainty that arises when attempting to account for the cumulative and synergistic effects of multiple chemicals. This is the chemical stew problem that confronts impacted communities, particularly in highly industrialized areas. Another structural reason why environmental laws do not adequately address environmental justice concerns is that environmental regulation often must be cost justified, and the various methodologies employed in cost-benefit analysis, such as discounting human lives in long latency scenarios, also tend to disadvantage environmental justice communities. In addition, as pointed out by commentators, the cost-benefit enterprise itself is highly subject to manipulations of all sorts, resulting in some pretty counterintuitive monetizing of things that do not have a dollar value, like a human life, a debilitating illness, or even an IQ point. I'll quickly mention just one more structural problem in the environmental regulatory arena. That is the inability of underfunded grassroots community groups to adequately have their concerns addressed in an arena dominated by well-resourced, concentrated interest groups speaking in very technical language that the average person cannot understand. Nor do these groups have their own experts that can independently analyze the proposals that are on the table. In the 30-some years that environmental justice has been part of the regulatory landscape, there's still an unlevel playing field. Add to this basic problem the looming challenges that climate change will bring to particularly to vulnerable communities, as I'm sure Professor Gerard will elaborate upon, and you have an already dire situation that will only grow worse. Something has to be done to break the existing logjam and to move forward in a sensible way for all concerned. Could principles of sustainability have anything positive to add to this difficult conversation? I think they do. For one thing, employing the language of sustainability might broaden the more narrow frames I have discussed. The individual rights focus of civil rights and the chemical by chemical cost-justified approach in environmental law. The often quoted definition of sustainability, as noted earlier, is development that meets the needs of the present without compromising the ability of future generations to meet their own needs. There's a lot more to this simple definition than meets the eye. As Professor Dernbach noted, sustainable development is not about development in the usual sense. It's about pursuing social, economic, environmental, and security goals in ways that are more mutually reinforcing and supportive over time, not contradictory or antagonistic. Principles of sustainability not only consider but deliberately place an anti-poverty agenda within the core mission. So taken as a whole, sustainability takes the focus off of parts, the individual part, the environmental part, the chemical part, the economic part, and begins the task of looking at the integrated whole. It seems like a tall order, and my initial concern would be that much like environmental justice and its close cousin, the precautionary principle, the overarching principle of sustainability likewise can be criticized as being too vague and amorphous, and as such cannot reasonably be translated into coherent policy. Scholars in this area are undaunted, however. They're looking for common ways to move from the aspirational goals to policies and legal frameworks that implement sustainability in common sense ways. They've done so first by creating a broad spectrum of indices of sustainability and have set out to measure where we are in multiple categories. For example, we see indices in categories such as diverse as ambient toxics in air and water, fresh water supply, biodiversity, forestry, ocean resources, use of nuclear and fossil fuels, agriculture, municipal solid waste and contaminated properties, population, and per capita consumption, to name a few. Scholars have also looked to identify sustainable practices that already exist within these categories. From that inventory, so to speak, the work of integrating over the long haul economic efficiencies and social justice can begin. Another interesting aspect of the sustainability framework is that, like environmental justice, it can manifest as a bottom-up approach. Because so much of environmental justice problems stem from short-sighted land use decisions, historically up through the present, when principles of sustainability are introduced by various ways into local land use decisions, this too is where it gets interesting. In addition to this, states are also starting to become more vigilant about the impacts of local land use decisions that cause adverse disproportionate impacts. This, coupled with a largely citizen-generated push for smart growth, might together result in more environmentally just, sustainable local land use decisions. While the implementation phase of various smart growth recommendations is still in its infancy, and it remains to be seen to what extent various levels of government actors and public-private sector funding will incorporate environmental justice concerns within that framework, if they can manage to do so, there is a lot of potential to significantly change conditions in highly impacted and blighted urban areas. One area where there are positive signs of this is in certain brownfield redevelopment projects, which is the reuse of old, abandoned, or underutilized industrial sites. While in some respect brownfield redevelopment and environmental justice is still very much a mixed bag, and there are no comprehensive studies to confirm whether as a whole this is a successful endeavor, anecdotal accounts suggest that there is more of a tendency to bring the affected community into the process at an earlier stage, learn about their concerns. There's greater sensitivity to potential health and nuisance impacts. Importantly, project sponsors are, in this instance, more willing to leave behind the check-the-box mentality and make sure that the affected community benefits from the project. Now, procedure alone isn't going to solve the issue. If there is sufficient attention to designing truly protective engineering and institutional controls to contain any on-site contamination, then these projects start to look more like what an integrated, sustainable approach would call for. It is through these projects, perhaps, that we can start to develop workable, pragmatic approaches to sustainable practices. So that's the good news. But just as there's the potential for good, there's also the potential to lose our way. There are a few ways that the language of sustainability can be used in ways that are not environmentally just. For one example is to use anti-sprawl smart growth development to justify gentrification and the displacement of stable communities of color in the core of our urban areas. In another sense, what appears to be a good thing might unduly limit the concept of sustainability. There does appear to be an embracing of sustainable practices from the business and industry sector, but I'm not sure that the thinking here is the integration of social, economic, and environmental missions, nor do I sense that poverty eradication is core to this particular conception of sustainability. So while it's important to look for and examine sustainable practices with a view towards expanding these practices, it's equally important not to become complicit in the repackaging of business as usual in the garb of sustainability. It's got to be more than recycling or other forms of cosmetic marketing. Simply, we've got to police the term. Another troubling aspect of a more limited view might be hidden in its close tie to climate change. What can happen here is that we become so single-focused on retooling our infrastructure to carbon-friendly energy production that we forget about environmental justice concerns. The risk here is that we can actually create a new and more pernicious kind of inequity, moving from the inequity that is generated from that powerful mix of incentives that currently maintain the status quo, which I call status quo inequity, to what we might call the equity of imperative. We take the imperative of climate change and the unquestionable need to do something and to do something fast, and we use that to justify the siting of carbon-friendly but still troublesome facilities in those areas that historically have been at the end of that path of least resistance and the communities that live there. Examples might include the newly invigorated interest in uranium mining in Indian country without consideration of existing high concentrations of radioactive material still in the environment from past mining practices. The siting of uranium enrichment facility, waste-to-energy plants, wind and solar farms, high transmission lines, biomass facilities. Do you remember the craze for siting liquefied natural gas facilities, import facilities a while back? They all went to the Gulf Coast. Think about the new craze for hydraulic fracturing. All of these can be justified on climate change and energy security grounds. So while it is critical that we retool our infrastructure and site an enormous amount of new facilities in the process, we have to do so in ways that don't spark siting wars, and that, more importantly, don't disempower community, don't generate inequality, and generate economic justice. You know, a more subtle version that I want to quickly mention, a more subtle version of the environmental justice, climate-friendly policies was a conflict. It was apparent recently in the debate surrounding the opposition by environmental justice activists to California's carbon market. Noting that direct methods of carbon control on large facilities had great potential to reduce more localized co-pollutants, activists argued that California had in effect rushed to judgment in deciding upon carbon trading, and that the environmental justice implications of that versus other types of strategies had not been thought through adequately. This was a difficult issue, and time constraints preclude a more detailed description about the various positions. But I use it here to bring up an important point. The main concern seemed to be all about sustainability at the local level. Recalling the sinking ship metaphor that I talked about earlier, these communities in California are closer to the hole in the hull. But this same position did go against what was then the conventional wisdom of the time, that politically carbon trading was the most viable solution to controlling greenhouse gas emissions on a large scale. Without judging the merits of each of this position, which is a tricky thing to do, what we can say is that what appears to be a good idea for promoting sustainability at one scale may present a barrier to sustainability at another scale. Difficult trade-offs, to be sure. I hope I've given you a sense of how complicated these issues can be. But perhaps if we start thinking in terms of sustainability broadly, as including fairness, economic and social justice at all scales, and being particularly wary of thinking that the greater good justifies sacrifice from some segments of the population but not from others, then we might be able to devise solutions that more equitably distribute the benefits and burdens of a new way of living for all of us. Again, it's a tall order, and I hope that collectively we are up to the task. But I do believe that it could be one way forward to repair that hole in the hull. Or in my part of the country, we might say, Mother Earth is waiting for us to get our act together. Thank you.
Thank you very much. And we have about 10 minutes for questions for Professor Gauna. So does anybody have any questions?
You're asleep, right?
I'll start out with a question. You mentioned there toward the end of your talk, you talked about carbon trading. This idea, I think what you're implying is that if the cost of energy, which is mostly fossil fuel generated energy right now, if we imposed carbon cap and trade or carbon programs, it would increase the cost of energy probably quite a bit. And the implication I got from you was that that could disproportionately hurt lower income groups because it's going to be more difficult for them to adopt energy efficiency upgrades in their house or to do other things. They're going to have longer commutes on average, things like that. They can't afford to live close to where they're employed. So what do we do? I guess this really is the difficult question. But then how do we reconcile this? Because we heard this morning Professor McGinley talking about the poor people in the coal mine, or we saw the Sahel with the droughts and all these horrible people that are suffering. And yet if we do things that we think are helping to protect those people, we're going to end up hurting others. So is there any framework or any ideas you have for trying to reconcile? I think that's the ultimate question. But what are your thoughts on that?
Okay, a couple of points, Professor Wu. First of all, that wasn't what I was referring to, but that's a really good point. Secondly, I wish I had answers. You know, these issues are really tough. Let me back up a little bit and talk about the issue in California surrounding the carbon market was really not that it would make electricity more expensive and therefore hurt lower income people, although that is a concern. I think the issue in California was You have to think they're dealing with some really significant hotspot toxic stew problems in some of the areas, like in the Wilmington, San Pedro area in California. They were really looking at carbon control, direct carbon control, as ways to help bring down those really harmful localized pollutants. And so there was a little bit of a disappointment there when California just said carbon trading, which would mean that these large facilities like the refineries could simply buy credits to pollute and not bring down their own carbon emissions and the more harmful co-pollutants along with them. So there was that. And then there were also some procedural and other issues as well. That was the main concern. The concern has been that, well, you know, look, it's going to make energy more expensive for everybody, and it's going to hurt the lower income communities. And I actually got that when I testified before a subcommittee, which I thought, you know, there is sort of one sidebar remark that I have to make. I find that disingenuous when it comes from industry actors, that all of a sudden they're really concerned about, you know, what low-income communities can afford and not. So, you know, put that to the side. You know, it can be used strategically to, you know, to stop things from going forward. But there are ways to deal with that. I mean, we subsidize things all the time. We subsidize corporations. So that we can figure out solutions. It's not easy, but we can figure out solutions, weatherization programs, you know, tax rebates. We can figure out solutions to where the cost of electricity, you know, to poor people who, you know, don't have double-paned windows and things like that. We can try to figure it out. I'm not saying it's going to be easy, but it is workable. Yes, Professor McKinley. He's my buddy.
We've been talking about environmental justice, you and I, and our friends for a couple of decades.
Yeah.
And
Notice our gray hair, guys.
I caught the lawn.
Oh, okay.
I'm struck, and you talk about this, the options, civil rights law as a tool to achieve environmental justice, human rights, and regulatory law. But absent in conversations about environmental justice is the use of traditional common law rights and remedies. We talked about that at lunch. Anticipatory nuisance, trespass, negligence, sometimes are very powerful and easily understandable tools to deal with some of the core problems of environmental justice. I wonder if you comment.
I think that there's a lot of potential there, just like there's a lot of potential under the environmental laws themselves and the citizen suit provisions and the imminent hazard provision under RCRA, which is sort of like a nuisance, codification of a common law of nuisance. I do think there's a lot of potential there. The downside to that is that you often run up in the remedy phase against the weighing of the equities. And when you are talking about the costs, for example, of shutting down a facility in order to remedy the nuisance, you go right into that short-term economic model that has been the difficulty in a lot of instances. So that's a problem. I think more on the regulatory front, one of my friends who handles a lot of these cases, I wanted to have him come talk to my administrative law class about, because he says his greatest enemy is Chevron deference because of the high amount of deference that regulatory agencies get in implementing these laws, and the fact that they still are, I think, one of the things that strikes me over the years, and Michael Girard is going to get mad at me for saying this, because I know it, but I just look at the way that regulatory agencies have gone out on a limb in some very creative interpretations of their legal authorities at the behest of industry actors, treading on questionable legal authorities to put in place regulatory innovations, regulatory reform under the Clinton administration, and then it turned into another term.
Chevron, bubble.
The bubble, exactly. And so what happens is on that front, because the agencies, and as a lawyer, I can kind of understand why they do that, because they're very timid about interpreting their regulatory authority in providing more protection to environmental justice communities. It is odd to see that same interpretation of legal authority exercised more broadly at the behest of industry actors to relieve them somewhat from regulatory burdens. So there's a little bit of a disjunction here, but I think that it is still a significant barrier to really getting at some of these environmental justice concerns at the localized level. So on the common law front, and this is an oversimplification because I don't know the answer. The common law front, I think it's the remedy phase, and on the regulatory front, it's the fact that regulatory agencies are pretty timid.
One more question. Please, Professor Alpert. Unless there's... Go ahead. No.
I was just wondering, because I know you did work on the environmental justice panel for the White House, a lot of it recently in the administration. What's your opinion about the EPA's document about environmental law and environmental justice tools within EPA? And I guess I first approached that thinking it was going to be target outward tools that people on the, and it is to an extent, but it seemed like it was a little more directed to within the agency addressing what we were just talking about how they think about people within the agency think about what they can address. So it's saying, here's a window where when you are doing this action under this environmental law, you can think about environmental justice, et cetera. I just wondered what your perspective
I don't know
on that
yet.
was.
I don't know yet. I have to look over that document more carefully. I suspect, like in many things, it's a mixed bag. One area that I am a little bit familiar with in terms of tools that the agency is devising, and somebody mentioned earlier the idea of just enforce the law, guys. The EPA put together what's called the Environmental Justice Smart Enforcement Assessment Tool, and the idea of that would be to a broad screen for areas to figure out where the environmental justice problems are and to target enforcement resources within those areas. And I was co-chair of a committee to take a look at that tool. It was really cool because I got to work with some of the best environmental justice researchers in the country in terms of looking at that. And I was really struck by how difficult methodologically it is just to develop, and I'm not talking about identifying environmental justice communities, because you can't really do that with a necessary resolution using national databases, but just to identify areas of concern to be able to start targeting enforcement resources and making sure that the environmental laws are being complied with at a very base level is a difficult task. I mean, just that basic definitional problem. And so while I think that it's good to develop these legal tools, another one is the Title VI investigative guidance, that when you actually look into these legal tools, one of the problems I see is that the agency wants to maintain, for pretty good reasons, maintain flexibility in terms of being able to deal with different situations, while at the same time providing guidance that provides certainty to the regulated community. But in doing so, it leaves itself open to being able to take any number of options. And when you have very politically difficult decisions to make, it seems like the regulatory option that is taken is not one that is real protective towards the community. And so on the regulatory front, that's why I'm saying it's a mixed bag, and it's really hard to take a look at these wonderful documents that are put out and think through how they would actually work in practice, and whether they would give the regulated community, the regulators so much flexibility that they could weasel out of economically and politically difficult situations. And that's my concern. I don't know if that answered your question, but I'm trying to kill 10 minutes.
All right.
Not really.
Well, join me in thanking Professor Gowna one more time. Okay, now it's my privilege to introduce now our keynote speaker for this symposium. Professor Michael Girard is the Andrew Sabin Professor of Professional Practice at Columbia Law School in New York City. He's a graduate of NYU School of Law. He has an incredible level of experience in environmental law practice. Practiced for about 30 years, most recently with the law firm of Arnold & Porter, LLP, in New York. He is also currently the director of Columbia's Center for Climate Change Law, and he has chaired the 10,000-member ABA section on environment, energy, and resources. He has written or edited 9 books, told me last night. He has a couple of more that are getting close. So, and most recently his book, The Law of Clean Energy, Efficiency, and Renewables, is a great resource. So let's give a very warm welcome to our keynote speaker, Professor Michael Girard.
Let me just try to get this thing working here. Here we go. So I want to thank you for doing me the honor of inviting me to give this talk to the inaugural symposium for the Journal of Environmental and Sustainability Law. The topic that I'm going to be addressing this afternoon is, what does environmental justice mean in an era of global climate change? The U.S. environmental laws arose in the context of fighting mostly local or regional impacts. The Clean Air Act, the Clean Water Act, the Resource Conservation and Recovery Act, the other major U.S. environmental laws really were aimed at local conditions. Some of them extended over regional areas such as the fight acid rain and so forth, but they certainly were not designed to fit a global problem. In the early 2000s, out of frustration at the failure of the federal government to take action on climate change, a number of states and non-governmental organizations sued EPA in a case that became Massachusetts versus EPA, and of course the Supreme Court in 2007 ruled that the U.S. EPA does have the authority under the Clean Air Act to regulate greenhouse gases. But no one thought that the Clean Air Act is the ideal tool for that. There was widespread hope that the decision would spark Congress to take action. It didn't work, and so EPA has been using this authority it has, but it's not an easy fit. And in fact, 2 weeks ago in the U.S. Court of Appeals for the D.C. Circuit, there were 2 days of arguments on whether EPA has it right, whether EPA is using the tools it has under the Clean Air Act properly to regulate greenhouse gases. Environmental justice law likewise arose for the most part in the context of particular local siting disputes. The early cases were about landfills and incinerators and other projects that would have adverse effects in their local communities. Most of environmental justice law, as we've heard, is framed in the context of fairness in the siting and operation of particular facilities. So that, too, is not a good fit for fighting climate change. Climate change raises issues that we really haven't had to confront before as a society, issues of a magnitude and scale that are really beyond the capabilities of conventional environmental law or conventional environmental justice or civil rights law. So let me start by just saying a few words about the magnitude of the problem that's confronted. So looking back 800,000 years, today, was it 2008, the levels of greenhouse gases, carbon dioxide in the atmosphere, are far above anything for at least the last 800,000 years. Maybe a lot longer, but this is as far back as we can tell. They are going up at a very alarming rate, and the real question is just how high will they go when, and how fast will they get there. When we look at what kind of progress are we making in order to moderate the increase so that it stays within some degree of reason. This chart, if you look at the top line, the gray line, that is what's going to happen if, under a business as usual scenario, if there's no major change in what we do. The red line below that is what we will achieve under international pledges that the countries have signed on to, particularly after the Copenhagen negotiations of a couple of years ago. The dotted line below the red line is where we would get if certain additional measures that are discussed but haven't been committed to are taken. The lower lines are what we need to do if we're going to keep within some reasonable range. The black line is a 2-degree increase in 2-degree centigrade increase in temperatures over pre-industrial conditions, and that's basically the goal that the UN Framework Convention on Climate Change has gone to, and the dotted line below that is 1.5 degrees instead of 2 degrees. And the difference, one difference between 1.5 degrees and 2 degrees is that at 2 degrees many of the small island nations drown, and at 1.5 degrees they probably don't. But that's really an academic discussion between the 1.5 and the 2 degree, because we are nowhere near achieving those objectives in terms of what the nations of the world have committed to. In order to think about what it would take to get to where we need to be, I think you probably can't read this, but let me just explain. This is from a famous article by Professors Pakala and Sokolow a few years ago, the wedge analysis, looking at a whole suite of options that would be needed to be taken to achieve these reduction objectives. And some of them involve the siting of facilities, the siting of a lot of new facilities. So number 6, capturing carbon dioxide from baseload coal-fired power plants. Installing carbon sequestration at 800 power plants. With nuclear, number 9, adding 700 gigawatts. Your standard nuclear power plant generates about 1 gigawatt, so 700 gigawatts. Number 10, wind power. Add 2 million 1 megawatt wind turbines. It could go on, but the numbers are really quite staggering in order to get to be where we want to be. And we have not even begun to grasp, much less grapple with, the scale of work that needs to be done in order to get down to the climate change goals that we need to be. And this may indeed lead to some collisions with environmental justice concerns. The analysis that we have to look at has to expand both geographically and temporally if we're really going to understand what we're dealing with. And most evaluations done both under conventional environmental law and under civil rights law, I argue, are too narrow, both in terms of geography and time. So let me address 4 things. First, the environmental justice implications of mitigation of climate change, first at the domestic level, then internationally. Second, the environmental justice implications of adaptation to the climate change that is happening, again, first domestically and then internationally. Third, the time element, the consideration of future generations. And finally, I'd like to make some recommendations, some fairly painless, some quite painful. So first, starting with the environmental justice implications of mitigation. On the domestic side, I think most people believe that ultimately we really do need to put a price on carbon. And that could either be through a carbon tax or a cap and trade system, but there needs to be some kind of mechanism so that there are price signals, and without that we're never going to succeed. And I say that in a context where the U.S. has a history of globally low energy prices. This chart shows the electricity prices in the countries of Europe and compared to the U.S., and the U.S. is at the very bottom. We have and have long had some of the cheapest electricity in the world. Likewise, we have some of the cheapest gasoline in the world. Now, you may not know that if you listen to the news, but when you look at the comparison of U.S. gasoline prices against those of other countries, and the principal reason for that is that our taxes are so low. The gasoline tax in the U.S. is far below that of European countries and most other countries. So we have been coddled into really cheap energy, and unsurprisingly, we also have a high per capita energy consumption. That is not a coincidence. As was discussed, there are ways that obviously if the price of electricity and gasoline and other sources of energy go up, that will disproportionately hurt poor people, but we do have mechanisms for low-income fuel and electricity assistance that can deal with this problem. Now, Professor Ghana talked about the litigation in California, called AIR, Association of Irritated Residents versus the California Air Resources Board, and that was a challenge to California's implementation of AB 32, which is the nation's leading state-level climate control law. One element was a cap-and-trade system, and so that was challenged by a number of environmental justice advocates who believed that cap-and-trade might have disproportionate impacts, and maybe a carbon tax wouldn't, and that, as you heard, there wasn't enough attention paid to the issue of the co-pollutants, the conventional pollutants that come out of these power plants and other industrial sources that are regulated. Now, there are, as I think you heard, a number of other legal techniques that could have been used to control those coal pollutants. Both EPA and the California state regulators had the power to be more stringently going after the conventional pollutants, to adjust the emission standards accordingly, to go after hotspots, to go after inappropriately grandfathered facilities. I absolutely agree that the grandfathering of old facilities so that they can keep on chugging along is absolutely inappropriate. It's a problem with the Clean Air Act. I've litigated against some grandfathered facilities as a pro bono lawyer, and I agree that that's a problem. But I do not agree that it was a useful thing to be attacking the nation's leading climate control program. I think it would have been much more productive to be going after polluters than to be going after those who are trying to regulate greenhouse gases in this very important program. I also agree that there's a disproportion in the availability of expert assistance to many of these communities, and there are programs in New York, for example, that do provide funding assistance so that low-income communities can participate, can hire their own experts and lawyers and participate meaningfully in these kinds of facilities. But I think that that was an unfortunate set of litigation. An injunction was issued by the trial-level court against the implementation of the law. The injunction was stayed automatically on appeal. The case is still pending. But the cap-and-trade system is going to happen in California, but it has been slowed down. Another area where there are conflicts on the domestic side, as you've heard, and Professor Autka talked about this, is the siting of renewable facilities. And here, too, as we've heard, sometimes these are resisted because of genuine environmental concerns about what's happening. I have less sympathy for litigation that is based on aesthetic concerns, not wanting to see windmills in the distant horizon. There's some very difficult issues that arise. There's litigation pending against the Cape Wind project in Massachusetts by a tribe whose practices include certain ceremonies at Nantucket, which is part of their ancestral fishing grounds, and those ceremonies they say would be disrupted by being able to see windmills. I think that those raise very difficult issues that I think are going to recur. Another area where I think we're going to see more siting controversies concerns carbon capture and sequestration. This is a slide from a pro-carbon capture and sequestration outfit, but as you know, that is a proposed technology that would capture the carbon dioxide from major sources such as coal-fired power plants and store it, hopefully forever, underground in geologic areas. We have not yet begun to see the siting issues that would raise. I mean, if this ever kicks off the ground, there's going to be a need for literally hundreds of locations around the country where the CO2 would be stored and hopefully won't ever gurgle out. But there have been some instances in Europe trying to site these, and those have not met well. Those have not been well received. So those are just a few of the conflicts that arise at the domestic level. Let me now move to the international level. This chart looks at expected trends in CO2 emissions out to the year 2030. And the numbers at the, if you look at the lower level, this pointer doesn't work, but sort of through the green line around the middle, it's mostly flat when you add them all up, and those are essentially the major developed countries, North America, Europe, Australia. But then when you move up, you see quite a steep climb, and that's mostly China. Some of it, the China is the big blue area. India is above that. Also expected growth in some other of the developing countries, but the amount of growth that we're seeing in the world is absolutely dominated by China. Most of that is coal. This chart from a U.S. Department of Energy laboratory shows the construction that we've seen in the last several years and what is expected with coal-fired power plants in the U.S. and China. The U.S. is at the bottom. Very little construction of coal-fired power plants in the U.S. in the last few years. The combination of litigation, low natural gas prices, and other factors has really slowed that down. China is taking off like crazy. The amount of coal-fired power plant construction in China is astonishing. It will continue to be astonishing. Each of these plants is going to keep in operation for 40 or 50 or 60 years. The greenhouse gases that come out of these plants will stay in the atmosphere for 50 or 100 years. The global situation with respect to greenhouse gases is utterly dominated by the economic growth of China. Now, before the U.S. gets too outraged about that, it also has to be acknowledged that on a per capita basis, the U.S. has long been far above China and most other countries in what their emissions are. Here, the solid lines are the total amount of CO2 emissions from these kinds of sources in 2006, and China was already higher than the U.S. It's now higher still. But the yellow dots are the per capita emissions, and so as you can see, the only country that exceeded the U.S. was Australia, and then on a tier down below the U.S. were Russia, Saudi Arabia, Taiwan, Kazakhstan. China is way below. India is obviously far below that, but China is catching up to what the U.S. was. So the U.S. clearly has no moral authority to be saying that China shouldn't be able to emulate us in the economic growth. Professor Autke and I used a couple of the same slides, but let me talk about them in a slightly different way. So many people in China and India and many of these other countries really do live in energy poverty. Many of them don't have enough electricity for a light bulb. And so this chart shows sort of the relationship between the income level in a country and the kind of energy it uses. The U.S., of course, is in the upper right portion. We have information and communication technologies and cooling and appliances and all kinds of other things, and we use a lot of electricity for many purposes. And in the lower left are the countries that don't have electricity. They use a lot of biomass, and unlike the biomass that you've heard about in the U.S., in many of these countries, the biomass that they use for cooking is burning animal dung, a major source of biomass, in huts, in cook stoves in huts. So China and some of these other countries are trying to move up the scale. It obviously leads to more greenhouse gas emissions, but it also means that they can begin to have something of a reasonable quality of life. This is another chart that we saw, but one thing that's interesting about this in terms of the yellow is the millions of people without electricity, and so we see especially Africa and India, and then some of Southeast Asia. China actually has done a pretty good job of having more electrification. But then the green dot, millions of people relying on biomass. Again, a lot of this is these cook stoves that lead to horrible indoor air pollution. So this chart shows the breakdown by region of the number of people who die annually from indoor air pollution. And that is largely a function of these cook stoves. And the numbers are enormous. So we see in Africa, 396,000 people die a year from indoor air pollution. In India, 484,000. China, 466,000. These are enormous levels of illness and death because of the lack of a modern energy system. And so the growth of energy use in these rapidly developing countries is certainly going to continue, and it is going to save a lot of lives, but it's going to have massive climate implications. And we haven't even, frankly, begun to figure out how to deal with the externalities of this massive increase in coal use. There are other aspects of mitigation of climate change that have important international implications. One of after energy use, the next major source of greenhouse gas emissions in the world is deforestation. And so under the United Nations Framework Convention on Climate Change and the Kyoto Protocol and so forth, there's a lot of effort to try to reduce deforestation. There's something called REDD, which is reduction of emissions from deforestation and degradation of forests. One problem with that is that many of these forests are populated by indigenous populations that undergo real hardships when the use of those forests is for the first time regulated. Another issue that comes up is the use of biofuels. An alternative to the use of petroleum is you reduce the use of petroleum if you grow more biofuels. The use of biofuels is way up around the world, but unfortunately in many places that's done either by tearing down forests in order to grow the crops that are the source of the biofuels, which has the problem I just mentioned, or by conversion of cropland from food production to biofuel production. And that in turn, of course, has the potential to increase food prices. So if we look at the percentage of household income resulting from food, unsurprisingly, that's going to food, unsurprisingly, it's the poorest countries that have the highest proportion of their household income going to food. We see here Nigeria, Bangladesh, Afghanistan, Kenya, and those are the households that are especially vulnerable to food price increases, which can be worsened by the conversion of land from food crops to biofuels. So this is about the impact of climate mitigation on some of these populations. Let me now turn to the effects of adaptation, of coping with the climate change that is coming. Climate change has a whole host of impacts on health. When we look at the principal direct effects, temperature rises, sea level rises, and increases in precipitation events, it both directly and indirectly yields a lot of adverse health effects. This is a map based on some UN information about what are the parts of the world that are so vulnerable to different kinds of climate change that they may lead to people fleeing, becoming climate displaced people. They don't technically fit within the legal category of refugee, because a refugee is someone who is fleeing political oppression or the fear of oppression, but it pretty much has the same effect. And so we see in the Sahel region of Africa areas that are prone to severe droughts, and drought conditions were one of the several factors that contributed to the horrific conditions in Darfur. Some similar things in lower parts of Africa. We see also desertification in certain parts of China and Russia. The blue dots are areas, great deltas that are highly flood prone. And so Bangladesh and the delta of the Nile River in Egypt, Mekong Delta, Vietnam, some others are vulnerable to very large displacement as a result of sea level rise. Ice melt in the Arctic, and we're already seeing some of that with the indigenous populations there being endangered. This is an environmental justice problem of massive proportion. The number of people who stand to be displaced by these kinds of climate conditions is just enormous, and they are overwhelmingly the poorest and most vulnerable people in the world. There's no consensus on how many people will be displaced. There are a number of different estimates floating around, ranging from 50 million to a billion. These numbers posed are based on a lot of different assumptions and what you include or exclude, but whatever it is, the numbers are massive, and the suffering that will be involved through this kind of displacement is massive. Some of it will be people fleeing from flooding. Some of it will be people fleeing from desertification and droughts, those kinds of conditions. Often they'll end up in refugee camps of this sort, and this in turn becomes the source of a lot of civil conflict. That living in one of these places is not a happy situation. An examination was done a few years ago of the sort of environmentally induced conflicts around the world over the last 30 years, and the size of the dot shows what kind of conflict it was, including the largest dot, systematic and collective violence, and the source of it, sometimes it was conflicts over water, sometimes land and soil, sometimes fish, sometimes biodiversity. And so there are lots of different opportunities for climate change to worsen civil conflict. Now, certainly at the domestic level, in the U.S., we have the vulnerability of some populations to climate change. The most famous, of course, is Hurricane Katrina, and an overwhelming proportion of the people who died in Hurricane Katrina were African American, and many of the people who were displaced were as well, because they were the most vulnerable, the least able to cope with this. The coastal villages of Alaska are vulnerable. One thing that will clearly happen as a result of climate change in the United States, as well as much of the rest of the world, is we will have much more severe heat waves, and if you don't have enough money to afford an air conditioner, you're much more vulnerable to heat waves and other extreme weather conditions. So we have this in the U.S. and we have it globally. Globally, we also have the issue of ocean acidification, sort of the evil twin of climate change that degrades fisheries and is a great hazard to communities that have relied primarily on that. So this kind of issue, the possibility of migration, for example, raises its own colossal environmental justice issues. For example, in these countries, where are they going to go? Who's going to take them in? There is not now any international agreement for who's going to take in these displaced people. There are a very small number of bilateral agreements. The U.S. takes in a small number of people from some of the Pacific nations, not because of climate change, but for other reasons. One argument is that the developed countries of the world, the countries that have benefited from and continue to have very large per capita greenhouse gas emissions, have an obligation to take in climate-displaced people proportionate to their historic contribution to the load of greenhouse gases in the atmosphere. And also taking into account the amount of land that they have. So the U.S. and Canada and Australia and Russia certainly stand out as at the top of those lists, but these are issues that are going to have to be dealt with. I also said that I was going to mention the issue of the effect of climate change on future generations. And this is based on the IPCC, the Intergovernmental Panel on Climate Change, showing projections as to CO2 concentrations in the atmosphere based on different scenarios about mitigating greenhouse gas emissions and land use controls. The key thing to look at in this chart is that these numbers don't diverge much. They don't really begin to differ much until around 2040 or 2050. In other words, it doesn't matter what we do in terms of mitigating greenhouse gas emissions, in terms of what will be the climate in 20 or 30 years. Now, beyond that, when you look at the end of the century, it makes a huge difference. And so it is absolutely essential we mitigate our greenhouse gas emissions. But most of the climate change that's going to happen in the next 2 or 3 decades is literally baked into the system and is going to happen. And so the adaptation measures that are necessary are going to be necessary regardless of what our emissions levels are. And so that is an unhappy fact, and it obviously makes it difficult to mobilize action when the beneficiaries are many years from now. Let me finally talk about some recommendations. And so I have 5 recommendations with escalating amounts of pain. And the first recommendation is the most painless and, in fact, feels good. And it's been alluded to before, and that's energy efficiency. This is a chart that the International Energy Agency put together in 2010, showing at the top we see the levels of greenhouse gases, of CO2 emissions, under a business-as-usual scenario. The lower line is what the levels would have to become if we are to achieve our objective of keeping down to 450 parts per million. And so as we look at the energy measures that the International Energy Agency says would need to be met in order to get to where we need to be, 19% of it is carbon capture and sequestration, 17% is renewables, 6% is nuclear, 5% power generation efficiency and fuel switching, 15% end-use fuel switching, and end-use fuel and electricity efficiency, 38%. Efficiency is 38%, far more than renewables and nuclear combined, half again as much as renewables and nuclear combined. And yet we've heard immensely more discussion about renewables and nuclear than we have about efficiency. That is an absolute misplacement of attention, of focus. We certainly need to talk about renewables and nuclear, but the potential for efficiency is so enormous, it needs to be front and center. And not only does it have the greatest potential, but it also has by far the lowest cost. This is a chart based on some numbers that were put together in 2008 by Lazard, showing the levelized costs of certain sources of energy, meaning that it includes both the capital cost, amortized over the lifetime of the facility, and the fuel cost and other ongoing operational costs. So we have, and then the span shows uncertainty ranges and various kinds of options. Energy efficiency is an outlier over to the left. It's the cheapest by far. In fact, under the most expensive scenario, energy efficiency costs less than any of the others under the cheapest scenario. Energy efficiency from an economic standpoint is far and away the winner. Another depiction of the same concept was put together in a series of reports by the McKinsey consulting firm showing the amount of cost or savings in reducing greenhouse gases through various scenarios. And so anything to the left of that center line saves money, anything to the right of the center line costs money. It's almost entirely energy efficiency on the left. And the energy efficiency measures overwhelmingly save a lot of money, whereas the renewables and other things tend to cost money. So my first and far and away most important recommendation here is really to focus very intently on energy efficiency as far and away the best thing to do, and it's painless. It saves money. It has no externalities. When you're saving electricity, you're not drilling for oil, you're not digging for coal, you're not fracking for gas. All of these externalities that Professor McGinley talked about, we don't have with energy efficiency. The second recommendation is that we have to accept the reality of higher energy prices through a price on carbon, and to provide low-income assistance to the people who would otherwise be hurt by it. The third, and I'm going up the scale of difficulty, is reconsidering our processes for approving individual projects. As I said, the number of projects, the number of new wind and solar and other kinds of projects that we're going to need in the coming decades is, I think, so massive that it's incompatible with a process of taking 10 years to approve a given project, doing it one at a time. I think that we're just not going to get anywhere near the scale of what we need to do if we resolutely follow those processes. And we need to come up with ways to do the full analysis, but do it perhaps in a more generic fashion, and to say that certain consideraons are valid reasons and other considerations are not valid reasons. That not wanting to see a 2-degree arc of a windmill 20 miles away is not a valid reason not to allow a wind generation facility. The fourth thing is to take a hard look at some of the technologies that pose risks but may also pose benefits. So I don't have an opinion on whether nuclear power makes sense from an economic standpoint or a safety perspective. I have some skepticism about whether, when you do a levelized cost, looking full out at the cost of nuclear, it really does compete effectively with efficiency and renewables, but I think that it has to be on the table as a serious option. And finally, and most painfully, I think we absolutely begin to be planning for mass migration, for mass displacement of people from parts of the world where there's going to be large numbers of people who, as a result of flooding and drought and other conditions, are not going to be able to stay where they are, and the developed countries of the world are going to have to start making plans to take them in. And some of them will have to come to New York, and some of them will have to come to Missouri, and some of them will have to be spread around. But I think that this is a global burden and a global crisis that will have to be confronted. Thank you.
the refreshments, which are going to follow this immediately. So there's going to be refreshments at the Fireplace Lounge, light refreshments right after this. But on behalf of the university and the Journal of Environmental Sustainability Law, I want to thank all of you for being here today. And I also want to present a plaque here to Professor Gerard. This is our keynote speaker. Let's get it out of the box. There we go. So, thank you. So I want to thank again all of the people who have helped with this, the board for the Journal of Environmental Sustainability Law, Environmental Policy Network, the law school, the professors McGinley, Autka, Dernbach, and Dean Dessum, and Professor Gauna, and I'm hoping not forgetting Professor Gerard, of course. Keep an eye out for the published articles that will ultimately come out in the inaugural issue of the Journal of Environmental Sustainability Law. So thanks. One more big round of applause for everybody who we had involved today.